Hello, I'm Tad Lipsky. I'm the Director of Competition Advocacy at the GAI, and this is a presentation on the partnership between economics and antitrust. This is not intended to be a comprehensive presentation on all the ways that economics is used in antitrust law. It's only a very top-level historical overview of the role of economics in modern U.S. antitrust law. Once you understand this history, it's probably going to be easier for you to sort through a lot of current debates about how economics and antitrust relate. For example, there's a lot of conversation recently about the so-called consumer welfare standard. And I think you'll understand a lot better what the relevance of all that is after you have a little bit of basic background. Economics and antitrust are, of course, they're both very old disciplines. As a matter of fact, they both have ancient roots. The modern origin of economics is usually traced to Adam Smith and a group of 19th century French economists named Cournot and Bertrand and Walras, whose names are still fairly important in discussions of antitrust economics. And antitrust law itself has roots in the classical period of Greece and also in the common law that emerged in medieval England. And the first modern national antitrust statutes were passed in Canada in 1889 and the US in 1890. So that's a very broad historic overview. Now, the main US antitrust laws, sections 1 and 2 of the Sherman Act and section 7 of the Clayton Act, are focused on conduct that harms competition. Very important and actually very helpful that our main statutes are so heavily focused on this one basic concept. There are, of course, limited exceptions to this. For example, section 2 of the Clayton Act, which is usually known as the Robinson-Patman Act, regulates a number of pricing and promotional activities, not necessarily with regard to their effect on competition. And similarly, Section 8 of the Clayton Act regulates interlocking directorates and management positions. And again, the standards of these two statutes are not focused strictly on competition, but they're the exceptions, and they form a very minimal part of the US enforcement picture. Now, when you say that your main provision is prevent restrictions of competition, it's an extremely vague standard, and it's been universally recognized since the Sherman Act was passed that that standard doesn't really provide a useful rule of decision in many antitrust cases. As the Supreme Court said in the Chicago Board of Trade case, every agreement concerning trade, every regulation of trade restrains. To bind, to restrain is of their very essence. So if the language were interpreted literally, there's a lot of common, ordinary, harmless, and beneficial business conduct that would be strictly prohibited. For example, would it be legal to sell shoes in pairs? You could say it was a restraint to require the consumer to purchase both a left shoe and a right shoe. And even if you were to allow the sale of shoes in pairs, maybe it would be a violation, maybe it would be a restraint of trade to include laces with the shoes, so the consumer didn't have the option of selecting laces of his own preference. So, and similarly, even in a common supply contract, say I'm a flour miller and I offer to sell you, the baker, 100 pounds of flour a week for the next month. Maybe that could be construed as a restraint of trade because you, the customer, you're not going to buy your flour anywhere else for the month, and I can't supply that flour to anybody else. So it's literally a restraint of trade. And then getting into another type of relationship that could be condemned by a literal interpretation of the phrase, a post-sale restriction on competition by a seller with the purchaser of his going business, a very uh, common, well-understood restraint that was respected at common law and was never intended to be condemned under the Sherman Act. Literally, it could be characterized as a restraint and therefore illegal. So the courts have struggled for a long time with exactly how to draw the line and what considerations to have in mind in determining which competitive restrictions are to be regarded as illegal and which are to be tolerated. Early Supreme Court cases seemed to take a rather literalist construction of the statute. And you'll find in a couple of early Supreme Court cases, US versus Trans-Missouri Freight Association and United States versus Joint Traffic Association, both cases essentially involved what we would call today railroad cartels. And the courts didn't have any difficulty saying that, that such agreements could not be defended on the basis that they were intended to set reasonable rates. And so this defense of the cartel arrangements was rejected, and the court refused to consider the railroad's argument that if you, that because of the heavy investment it takes to build a railroad, if you don't have arrangements of this nature between the competitors, competition quickly becomes destructive and leads to rates that are too low to permit a return on investment. So the courts, Supreme Court, one of the points it cited in rejecting these reasonableness defenses is that there was really no way it could determine the reasonableness of a rate. There was no objective standard that a court could apply. So this became a rather rigid rule. And as you see, this is within the first decade of Sherman Act enforcement. But there was a growing understanding that some restraints might be tolerable based on some kind of reasonableness defense. And in fact, one of the leading sources of this point of view was a decision rendered by Judge Taft of the Sixth Circuit, later Chief Justice Taft, later also President Taft, in US versus Addiston Pipe and Steel. It was a pipe cartel, but Taft was drawing a contrast between cartel agreement and the kind of restraint at common law that was upheld because it was reasonably related to the main purpose of a lawful transaction, like the sale of a business. So the pivotal year for antitrust was really 1911, when a series of Supreme Court decisions kind of cast the scene for the next half century or so. In a private case actually challenging resale price maintenance, the court held really on the basis of very limited and imperfect economic reasoning, if that's what you'd call it, that vertical price restrictions should be treated as per se illegal. But then in two major cases against leading trusts of the day, one, the Rockefeller Oil Trust in United States versus Standard Oil of New Jersey, and in United States versus American Tobacco, the Supreme Court determined that the default rule, in other words, outside the cartel context and outside the context of vertical price fixing, the rule of reason would apply. Well, there was, and the rule of reason, of course, would permit the defense of competitive conduct based on facts and circumstances and based on pro-competitive justifications and so forth. So these decisions actually were regarded as quite conservative on the part of the judiciary, and it led to a backlash. This was in the midst of the progressive era, and there were demands for legislation that led ultimately to passage of both the Clayton Act and the Federal Trade Commission Act, which somewhat broadened the idea of what competitive restraints should be condemned under antitrust law. And of course, in the case of the FTC, created this much broader concept of unfair methods of competition in the hopes that the FTC might reach out to condemn behavior more enthusiastically than the courts have been willing to do. Well, antitrust had its ups and downs. Of course, the progressive era came to a pretty abrupt halt during World War I, and then with the election of Warren Harding in 1920, followed by Presidents Coolidge and Hoover, enthusiasm for aggressive antitrust enforcement was pretty scarce. There was a revival in the Roosevelt administration in the New Deal years, but ultimately, the critical period for the evolution of antitrust doctrine in the US courts and agencies proved to occur starting roughly after the war. I've dated this period from 1947. It was the first explicit declaration by the Supreme Court of a new per se rule, which was the per se rule against patent tie-ins. That allows me to provide a clear beginning at 1947. It also conveniently gives me an exactly 25-year period up until the peak of the per se takeover period, which was 1972, as I'll explain in a minute. But the courts, with the enthusiastic support of the federal agencies, began to place more and more restrictions into the per se category, the category that did not allow the use of economics and did not allow the presentation of a defense by somebody accused of an antitrust violation. In 1967, all vertical restraints were declared per se illegal in the Schwinn case. And by 1972, virtually every form of business conduct considered under the antitrust laws was either per se illegal, or for structural transactions and large firm conduct, the deck was heavily stacked against defendants. And I focused on the 1972 Supreme Court decision in United States versus Topco Associates, a group of independent grocery stores that banded together in an effort to create their own private label brand so that they could compete with the larger grocery chains like A&P. The district court thought the arrangement was entirely reasonable, but the Supreme Court not only knocked down the district court decision and declared the arrangement per se illegal, it actually mocked the use of economics in antitrust law. And I've quoted on my presentation slide, I've quoted the key footnote in Topco, where basically it says that the use of economics leaves courts free to ramble through the wilds of economic theory. So the court did not show many props for the idea of economists and using economics in antitrust cases. And aside from the per se rule itself, in 1963, the Supreme Court established a structural presumption in merger cases. High concentration increased by a merger would be presumptively unlawful. And then in United States versus Vaughn's Grocery, a 1966 case, it involved a couple of competitively inconsequential grocery chains in California. And nevertheless, the court struck it down, which led Justice Stewart to say in dissent that the only consistency he could see in the rule was that the government always wins. So a very high watermark for the strict merger enforcement doctrine of the per se era. And a similar evolution was apparent in the Section 2 monopolization law. In 1945, in a case, United States versus Alcoa, this had actually been started by the very aggressive Assistant Attorney General in the latter part of, appointed by Franklin Roosevelt in 1938. Uh, the case is interrupted by the war, but after the war, this decision came down, and Alcoa was condemned for expanding capacity to meet demand. And the Alcoa case really stood for this very aggressive presumption against monopoly conduct. Really, if challenged, the monopolist could only show that the monopoly had been thrust upon it, even if its conduct had been entirely reasonable and ordinary. What the phrase honestly industrial was used. So at about the same time, of course, a lot of these per se rules came under criticism from a variety of sources. Scholars and economic policy experts started to generate a fairly substantial literature that was critical of this of the per se approach and these very heavy presumptions that applied in the antitrust area. And coincidentally, just about the time that TOPCO was decided, the US economy started to run into some very substantial headwinds. A number of major US industries like automobiles, consumer electronic products, and machine tools started to lose competitiveness to Asian and European firms. Excuse me. And on the macroeconomic side, stagflation made an appearance. You had rising unemployment and rising inflation at the same time, and very troublesome trends in the US trade deficit. In fact, this is symbolized and to some extent exacerbated by the so-called Nixon shocks that were announced in August of 1971. The Nixon administration ended dollar gold convertibility, imposed a 10% import surcharge as a way of combating these trade deficits and the loss of competitiveness, and actually imposed a 90-day wage and price freeze, which was followed by a period of wage and price controls. Now, these lasted only a few years, but with the major exception, however, of energy price controls, which were not removed until Reagan's inauguration. And in fact, Reagan felt so strongly that they were a mistake that he actually arranged to have these energy price controls eliminated on the very day he took office. As a matter of fact, he signed the papers on his way from the inauguration podium on the front of the Capitol to the traditional luncheon with the members of Congress that occurs in the Capitol Rotunda immediately following the inauguration, but prior to the parade down Pennsylvania Avenue to the White House. So that's how strongly Reagan felt about the energy price controls. In any event, by the time of the Carter-Reagan transition, inflation and interest rates were running at record highs, and unemployment in early 1982 actually got over 10%, which was a level not seen since before World War II. So, as I mentioned, there was a lot of antitrust literature criticizing the per se rules and the judicial prohibition on the use of economics. Now, one popular fallacy is that this was all the brave work of a hardy group from the University of Chicago. But in fact, the movement to introduce economics into antitrust law and policy was much broader than that. And in fact, one of the earliest and most aggressive proponents of using economics was a Harvard man, Donald Turner, a name that's probably recognized by many, if not most, antitrust practitioners of the day. Professor Turner had earned his PhD in economics at Harvard and had gone to teach at Yale, at which time he also matriculated and obtained a Yale law degree. And he was considered one of the preeminent antitrust scholars of the day, equal in stature with Philip Arita. And he vigorously advocated reliance on economics for antitrust enforcement. Not always in a lenient direction. He was actually an advocate for no-fault monopolization laws, and at one point even advocated for for adoption of the recommendation of the so-called Neal Commission, that there be a deliberate, organized deconcentration of oligopolistic industries. So in any event, when Professor Turner became President Lyndon Johnson's first Assistant Attorney General for Antitrust in 1965, he opposed a tax on bigness for its own sake, and he opposed the incorporation of non-economic goals in antitrust. He was very much in favor of basing all antitrust enforcement on rigorous economic analysis. In accord with that vision, he published the very first Department of Justice merger guidelines in 1968. And these guidelines specified market share thresholds that were likely to result in government challenge to not only to horizontal mergers, but also to vertical and conglomerate mergers as well. Interesting fact, at the time, antitrust division attorneys were outraged that Turner's guidelines actually suggested that for mergers that did not meet the thresholds, that the transaction might escape federal prosecution. They very much preferred a regime in which they could successfully challenge any merger that they thought was justified. So kind of an interesting way that perspectives change over the years. Now, all of this economic critique of the per se era rules eventually had an effect. And the first glimmer was this case called United States versus General Dynamics, a merger of coal producers that reached the Supreme Court. The government had challenged the acquisition, relying on market shares and the market share presumption of Philadelphia National Bank. But the government had relied on market shares calculated on the basis of prior production. And the lawyers for the parties argued that because most coal production most coal supply is done under very long-term contracts, the relevant data that reflect the competitive strength of particular firms should be the free reserves they had available. So even though you might have been a big firm in the past and have a current production level, if you had no coal reserves available to commit to a new contract, you were not a significant competitive force in the market. Well, the Supreme Court was persuaded by this argument and reversed the decision condemning the merger. But it was subject to interpretation, with those favoring the more traditional government position and the heavy market share presumption and the stricter approach. Their reading was the government had simply messed up and used the wrong data. There was no real change in Supreme Court antitrust doctrine involved in the case. But there was a broader view of the case at the time that by considering these economic arguments, perhaps the court's hostility to the use of economic analysis and its slavish preference for per se rules that had been so vividly on display in other recent cases like Topco and Vaughn's Grocery, perhaps that was weakening, but it was very much debatable after the General Dynamics decision in 1974. So light dawns in 1977 when a case involving garden variety territorial vertical restraints reached the Supreme Court, Continental TV versus GTE Sylvania. And the case is significant even today, precisely because it contains such a clear statement by the court that was the diametrical opposite of what had been stated in Topco. In Topco, the court had mocked the use of economic reasoning, saying that it would lead to great uncertainty and leave everybody to wander through the wilds of economic theory. And here you have the core of the decision saying departure from the rule of reason standard must be based upon demonstrable economic effect. And so the court overruled Schwinn and returned all of the non-price restraints to the rule of reason category. Only price restraints remain subject to the Dr. Miles rule. And Justice White, being a sharp guy when it came to antitrust analysis, concurred in the judgment, but he correctly predicted that the court was setting itself up for a reversal of the Dr. Miles rule because he did not feel that the per se rule against vertical price restraints could withstand economic analysis. And he was perfectly correct, but for various reasons, the per se rules on price restraints, vertical price restraints, didn't fall until 30 and 40 years later. State Oil versus Kahn in 1997, which struck down the per se rule against maximum price restrictions, and finally Legion versus PSKS in 2007, which struck down the minimum vertical price restriction per se rule. So all verticals are rule of reason at the federal level now. Well, following Sylvania, you find a period really extending down to the present day, where the principle that economic analysis should be relied upon in sorting through predictions about and interpretations of how competitive conduct plays out. This is again and again the Supreme Court returns to this theme. In the Matsushita case in 1986, involving when an inference of conspiratorial conduct is appropriate. In Brook Group versus Brown and Williamson Tobacco in 1993, which set out the basic framework of predatory pricing analysis. In Verizon versus Trinco, where the main issue was monopoly refusal to deal. In Illinois Toolworks versus Independent Inc. Illinois Toolworks versus Independent Inc. involving the presumption of market power for possession of a patent. And in Bell Atlantic versus Twombly, which again was an inference of conspiracy case. So, you had this very broad bipartisan consensus that originated at the time of Sylvania in 1977, and really comes down to the present day, subject to some recent debate that we'll discuss in a minute. But it's really been a question of which economists do you believe has really been the main issue in a lot of the key antitrust cases outside the cartel realm. So I think one helpful way to sort through the meaning of this revolution in Supreme Court thinking and agency thinking on the relevance of economics is to appreciate the distinction between what economists would call a policy instrument as distinct from a policy goal. The policy instrument is the thing that the regulatory agency or the antitrust agency actually puts its hands on and changes under the statutory authority that it possesses. So as I mentioned at the outset, fortunately, the question of what is the policy instrument in antitrust is pretty much crystal clear. The instrument is prevent restrictions of competition, either restraints of trade, anti-competitive transactions, or monopolizing conduct or conspiracy to monopolize and so forth. The prevention of restrictions of competition is really the way that antitrust law is authorized by Congress to act. Any discussion of goals is a discussion about something that lies outside of the statute. There may be aspects of legislative history that relate to it. There may be good and bad and indifferent ideas about what the goals should be. but they all have to be consistent with what the statute actually commands, which is that the agencies and the courts prevent restrictions of competition. So some principled guidance is needed when you're applying that prohibition. And economics is just the discipline that we employ to determine by scientific method rather than simply dogma or opinion what should be the rule of decision that's most likely to be economically beneficial in any particular case where the outcome of the decision under the statutory standard might be in doubt. And at the very least, economics would be relevant even if you just adopted the very limited principle that antitrust rules shouldn't be damaging to the economy. The ultimate takeaway from the per se rampage, the 1947 to 1972, is that the failure to acknowledge economic reality has very negative consequences. That's basically what Sylvania held. Departure from the rule of reason, the rejection of defenses, and the willful ignorance of economic analysis is not permissible. You have to be able to use economics to judge the sense of what you are doing in order to have a productive and coherent antitrust policy. And in my view, once you really appreciate the difference between policy instruments and policy goals, this consumer welfare debate that's taking place at present is actually kind of a red herring. None of the antitrust statutes refer to welfare, and no agency or court is really capable of making a detailed decision case by case whether the behavior observed in this particular case increases or decreases any kind of welfare. What the statute has commanded us to do is prevent restraints against competition. Where the answer to that is obvious in a cartel case, we don't need to talk about goals or what kind of welfare we might be advancing or protecting. It's only in the ambiguous cases where, in order to formulate a sensible rule, you want to know which rule is most likely to enhance the basic goal of increasing output, productivity, and advancing economic objectives in general. So antitrust cases should have no pretense of being able to distinguish between consumer welfare and producer welfare, if that's what's meant. It's really a question of whether or not to use economic science to judge whether a certain type of conduct is more or less likely to be to advance economic goals. So some have advocated that we adopt a consumer welfare standard, meaning that you actually try to measure how much consumers benefit from specific conduct. But this is contrary to the statutory language. The statutory language says protect competition. So it's not the law. As a matter of fact, a strict consumer welfare standard in the sense of maximizing consumer benefit is actually contrary to the statutory language. And as I say, in any event, is not a practical rule of decision because it can't be judged in each individual case, at least not by courts and agencies. It also happens to be a wealth destroying policy. And it would limit production and growth in what we believe to be the main objectives of having an antitrust law in the first place. For example, it would justify joint purchasing cartels. That is not a rule that would enhance economic objectives. But once you get the distinction between the policy instrument and the policy goal, and it's obvious that the use of economics is the way to go, and you should not, as Donald Turner argued, you should not make antitrust a mixture of social goals because it's both damaging and unworkable. Courts have no apparatus for assessing the success of particular decisions in advancing goals inconsistent with antitrust goals, with the economic goal, and they're trying to do something that should be left to legislatures and other overtly political processes, and particularly uh, those who claim that there is a redistributive aspect to antitrust. Uh, it's not clear to me how you could possibly imagine that incorporating redistributive objectives in particular antitrust cases would be an improvement over dealing with those issues in the determination of tax and fiscal policy. It's almost impossible to figure out what the redistributive consequences of a specific antitrust decision would be. You'd have to know who owns the shares or who holds the debt of the firms that are involved, and how is that going to be affected by the conduct. It's just not the kind of fodder that courts and antitrust agencies know how to chew through. So, in conclusion, because the application of our basic antitrust statutes that say protect competition, do not permit restrictions of competition, because the application to specific conduct requires principled guidance, a literal approach is not workable. You have to use economics, at least to determine that your antitrust rule is not doing harm, which is the very vivid lesson taught by the consequences of the rules adopted in the per se era. And that's why reliance on economics has been supported ever since by a very broad consensus, a bilateral consensus of the antitrust community. And we've had a period of absolutely unprecedented US economic innovation and growth since Sylvania. And it all illustrates the wisdom of that approach. The main question will always be, what rule is most likely to lead to the greatest economic benefit for the whole society? Distribution of the benefits is not a question that antitrust needs to address. It's not a question that really can address, because neither our agencies nor our courts have the empirical apparatus. And it would be impossible for them to weigh and balance economic objectives against other goals. So that's why I said at the outset that if you understand the history of how economics came to be such a major component of antitrust decision making, you'll see that the consumer welfare versus total welfare debate is really a red herring. We just want to make sure that good, solid, well-supported economic science is always the basis for choosing what conduct will be condemned and what conduct will be permitted. You may not always like the decision. There are some Supreme Court decisions even I didn't like after Sylvania. The one that refused to overrule Brulot versus Ties, the patent antitrust case. But in general, economics has ruled the day, and it's been very much to the benefit of antitrust enforcement, the clarity of the standards, the degree of compliance, and ultimately to the benefit of the society. So thank you very much. Hope you enjoyed.